All right. Good morning. Thank you so much for joining us today. Today, we are going to talk about Social Security disability benefits following a stroke. If you have had a stroke and you are no longer able to return to work, this is the webinar for you. If you are joining us on the live, thank you for joining us. As I will kind of allude to throughout, I do not take questions on the live webinar, and the reason for that is not because I'm not interested in taking questions and trying to help in any way that I can, but because the questions that I would need to ask in response tend to get a little personal. And so for that, I do request, if you're watching on the live, we'll drop a link in the chat, and that way you can go ahead and click that link and schedule a time to talk with us. And that way we can answer any questions that you have and get all of the information that we might need to be able to help you and get you a good solid answer. If you're watching us on the replay, thank you for joining us. And that link to the schedule a call is going to be down below. So if you, like I said, we can't answer any questions in the live. On the replay, we can't really answer any specific questions in the comments. But if you have a question, feel free to give us a call. Our contact information will also be at the very end of the webinar as well. So without further ado, let's get started. Today, we are going to cover some Social Security disability basics, some guidance from the agency. We will look at the listing that is specific to strokes. There are three different types or three different avenues for potentially getting disability benefits under that listing, which is 11.04. We'll also talk about some considerations, and then finally, how an attorney can help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildonor. I'm an attorney, the founding attorney of Beacon Disability, which is a law firm based in Florida, where we exclusively practice federal administrative law. We specifically focus on helping clients with their agency-level Social Security disability and supplemental security income matters. So if you have a question, you don't have to be in Florida. If for some reason we cannot help you, we do try to put you in touch with somebody local to you who can. But again, feel free to reach out. That link is in the chat on the live. It's down below on the replay, and then our contact information is at the end. Okay, so a little bit disability overview. So there are two different Social Security disability programs. There's SSDI, or Supplemental Security, or no, Social Security Disability Insurance, getting ahead of myself. And then there's SSI, which is Supplemental Security Income. So both programs are going to require that you be disabled and unable to work for a period of at least 12 months due to physical and or mental impairments. However, you do not have to be disabled for those full 12 months before applying. But if you apply, and we'll actually get to the stroke specific timeline in a minute, but if you apply before that 12-month period is up, what Social Security is going to be looking at in the medical records is, does it look like you will be out of work for at least a year following the stroke? So again, you don't need to wait 12 months to apply. And in fact, if you are applying for SSI, you want to apply sooner rather than later. Same with SSDI, but SSI, the application date is very important, because Social Security often cannot pay benefits prior to the date of the most recent SSI application that you've got. So you'll want to at least get the application in as soon as possible. There are timelines with SSDI benefits, but you can kind of go retroactive with those a little bit in some respects. The difference between the programs, they both require that you be disabled and unable to work for a period of at least 12 months. The difference is SSDI requires that you have a work history. It requires that you've paid into the system and you have amassed sufficient credits. Typically, we say that you have to have worked 5 of the last 10 years, but there are exceptions to that rule, especially for younger individuals. With SSI, there's no work requirement. You could never have worked and qualify for SSI, but there are income and asset restrictions. So on SSI, there are income restrictions that vary depending on household size and a bunch of other factors. So we don't get too deep into the income restrictions, but the asset restrictions for SSI benefits, you cannot have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married and qualify for SSI benefits. So each program has kind of 2 prongs. The first prong is with SSDI, you have to have the work credits. With SSI, you have to have below the income and asset thresholds. And then the second prong in each, which is the same, is that you have to be disabled and unable to work for a period of at least 12 months due to one or more physical or mental impairments. Okay, so that's a little bit of background and basics on the two programs. When you submit your application, whether it's for SSDI or SSI, the very first thing they're going to do is see if you meet the non-medical prong. So with SSDI, they're going to make sure you have enough work credits. With SSI, they're going to make sure your income and assets are below the necessary thresholds. If you pass that test for each one, or just one of them, it doesn't matter. But if you pass that first test, then they will move to the medical portion of your claim. There, they will very first look to see, are you currently engaging in substantial gainful activity? That means, are you working over 20 hours a week? Are you earning more than about $1,400 a month? Okay, if you're engaging in substantial gainful activity, the analysis will stop there. The agency will say you aren't disabled because you are engaging in substantial gainful activity, and therefore, by our definition of disability, you are not disabled. Okay, so if you are engaging in substantial gainful activity, analysis stops there, you'll get a denial. If you are not engaging in substantial gainful activity, the analysis moves to step 2. Social Security will request your medical records, they will review the medical records, and they will determine, do you have at least one severe medically determinable impairment? If after looking at the medical records, they don't see any severe impairments, they'll deny the case, saying that you don't have any severe impairments. If you have at least one severe medically determinable impairment, they will then move to step 3 to take a look at the listings. Like I said, today we're going to talk specifically about the stroke listing. They will look to see, do you meet or equal one of the listings? If you do, then the analysis stops there and you'll be approved. If you don't meet or equal a listing, then Social Security will, again, using those medical records, create a residual functional capacity for you. And that is what Social Security believes you are capable of doing on a physical and mental basis. They will take that RFC, they will look to see, can you go back to do your past relevant work? Can an individual with your RFC do your past relevant work? If you can go back to your past relevant work, the agency stops the analysis, they send a denial. They'll say, you can go back to do your past work, you're not disabled under our rules. If you cannot go back to your past work based on your RFC, what they then look at is, can you engage in any other work? Are there any other jobs in the national economy that exist that an individual with your RFC, your age, your education, your past work experience, your transferable skills, are there any jobs that such an individual can do? If there are other jobs that you could adjust to with your RFC, age, education, past work, transferable skills, if there are other jobs that you can adjust to, then Social Security will find that you're not disabled, and they'll say you can adjust to other work. If there are no other jobs available and you can't go back to your past work, then at that stage, Social Security will find that you are disabled under their rules. Okay, so as I alluded to before, there are 3 avenues to meeting the listing that Social Security will often use to evaluate claims following a stroke. One of the avenues will require evidence of sensory or motor aphasia that results in ineffective speech or inability to communicate. If you don't have that, then there are still 2 other avenues. No matter what Social Security, they like to see evidence from 3 months after the stroke. And that is so they can better understand the impact that the stroke actually has on your physical and mental functioning. They don't always need 3 months, but they will typically, if it's before the 3-month period that they get it and they're ready to review it, they'll typically wait until after the 3 months. Again, there's an exception to every rule, but generally they do like to see evidence for about at least 3 months to see what it's going to look like. Are you going to, does it look like you're going to be able to make a recovery in the next year? Because again, you've got to be disabled and unable to work for at least a year. Or is this a long-term issue that we're going to be doing a lot of PT, OT, different types of therapy, and or other treatments. So here's the first avenue using listing 1104, which is titled vascular insult to the brain. This is the one that does for 1104A is going to require the sensory or motor aphasia. And that aphasia has got to result in ineffective speech or communication that lasts for at least 3 months after the stroke. That's going to go off again in a few minutes, so I apologize. 1104B is the second avenue, and that is also vascular insult to the brain. This avenue is if you have a disorganization of your motor function in two of your extremities, which are your lower extremities, your upper extremities, or one of each. And the disorganization of motor function in your two extremities has to result in an extreme limitation in your ability to stand up from a seated position, your ability to balance while standing, your ability to balance while walking, or using your upper extremities. This disorganization must last for at least 3 consecutive months after the stroke. When talking about extremities, it of course includes your legs, it includes fingers, wrists, hands, arms, and shoulders. So that is important to note as well. And then the third and final avenue is you have a marked limitation in physical functioning and in one of the following areas of mental functioning, and the marked limitations in the physical and mental functioning have to last. Again, there's that 3 consecutive months after the stroke. And so the mental functioning areas are understanding, remembering, or applying information, interacting with others, concentrating, persisting, or maintaining pace, and being able to adapt or manage yourself. Okay, so those are the 3 paths through a listing. Again, as we talked about, if you don't meet or equal one of these listings, if your RFC is such that you're not able to go back to your past work or any other work, you can still be found disabled under the Social Security Administration guidelines. You just won't be found to meet or equal the listing that they've got set up for stroke. The other thing I want to make sure to mention is if the stroke caused vision loss, then there are separate listings for vision loss that Social Security may also consider. So if there are other body parts that the stroke has impacted, it's possible that the Social Security Administration will actually evaluate your case under a different listing if the residual impact is for a different body part, if that makes sense. Okay, so certain considerations you want to make when thinking about applying for disability. As I have mentioned, medical records are critical. The issue in a Social Security case is not just can you go back to your past work, but can you do any job that exists in the national economy? And so to that effect, as I say, again, I start and stop this slide with medical records are important. They help Social Security it gives color to what you're saying. It's not that Social Security doesn't believe you and they don't think that you're being truthful, but it's that they need to see the medical evidence. What is causing these limitations that you're having? Does it make sense? Does it match up? Does it add up? If you are over 50, then the grid rules may apply, particularly if you've got physical limitations as a result of the stroke. And then again, functional capacity can also be relevant, particularly if you don't meet or equal one of the listings, either the stroke listing or a different listing regarding the body function that is continuing to be impacted following your stroke. All right, how can an attorney help you? This is not an exhaustive list, of course. This is just some of the things that first come to mind. One of the things that we do is we help provide guidance on what correspondence from Social Security actually means. A lot of times I'll get clients who call frantically stressed out about a letter they got, and I don't understand what it means. Well, we help kind of digest that for you and explain whether it's something to be concerned about or not. We can file appeals. If you are already a client of ours and you get a denial, we reach out to each other. If you're a client of ours, you've probably heard me say, you may get yours a day or two before me, and I might get mine a day or two before you, but we both should get it in the mail. But we both communicate with each other to make sure that we're both receiving mail. And then we get necessary appeals filed. If you don't yet have a lawyer, and you contact the lawyer in a certain amount of time after getting a denial, then the lawyer may be able to file the appeal for you. If you call the lawyer the day the appeal is due, they may tell you to do it yourself, and they'll come back through and tidy it up. We do review your medical records in your case file. As part of that, we also may discuss what additional records might be helpful in your case if there are options for you. We do review your documents for accuracy and completeness. If you've watched some other videos or attended other webinars, you likely know that we don't fill out the questionnaires that Social Security sends to you regarding your functioning on a day-to-day basis, but we can review them. We can also discuss what Social Security is looking for in those forms. We don't fill them out for you because you know what you go through better than anybody else. And so, like I said, we're happy to review them to make sure that you were comprehensive and honest, and we can discuss what they are looking for to ensure those comprehensive and honest answers that you will ultimately submit. We also work with you to provide relevant updates to Social Security throughout your claim. And if and when we receive updates from Social Security, we relay those back to you to keep everybody on the same page. If you are at the hearing level, we prepare you and potential witnesses for the hearing. If it's not feasible or possible or a good idea to have a live witness at the hearing, we discuss other avenues to possibly get that witness testimony in and on the record. So again, that is just some of the things that we can help you with. And it's not just us. Any Social Security attorney should be doing these things. If you are a current client or would like to be a client and you have questions, always feel free to reach out. This is our contact information. And I appreciate you joining us today. Again, I don't take questions on the live. I can't really answer any specific questions on the replay in the comments, but please, we will drop the link again in the chat on the live. And on the replay, it is down below to schedule a call at a time convenient for you where you and I can get on the phone and chat and see what we can do to help you. So thank you so much for joining. Have a wonderful day.